right, if everyone's ready, we'll go ahead and get started. There were agendas over by the door, and also handouts from Steve Potts there for you if you'd like them, as well as our U-PRISE brochure and our cards for Dr. Leah Ryder, who's our Director of Pupil Services. My card is there. I'm Shannon Brown. I'm the supervisor of now secondary special education. We also have another supervisor who's new this year, Kendall Warren. She's now our supervisor of elementary education. Not to say that if anyone needs help, we're not going to work together, but that's sort of how we divided and conquered this year with some additional support. So all of our cards are over there. There's also fun swag. Feel free to grab a pen or a Post-it note. I keep trying to give those away. So our website's on there. I did pull it up here for you if you're looking for it. If you just go to ucfsd.org, it's very easy. You can go to departments and go to special education, which is the page I'm already on. And then U-PRISE is one of the drop downs right here. And here's our brochure is linked. Our Twitter is on here if you follow Twitter, so we'll tweet out about the meetings. All 4 meeting dates are on here. We've already have them scheduled for this year. This is our first one. We're going to be talking about special needs trusts, guardianships, and powers of attorney with Steve Potts, who's here from her Potts & Potts law firm. And Steve also has connections to our district, so that's nice. In November, we're going to do a community safety meet and greet, and so we're really excited to have Poe Marlin Fire Company coming out, as well as hopefully Longwood EMS, and also the Avondale State Troopers. So students will have an opportunity to, bless you, to meet those law enforcement and emergency services personnel. They will have the opportunity to climb in a fire truck, a police car, and an ambulance, to try on their outfits, to not be afraid of them, to learn from them. They'll be handing out information for parents and children, coloring books, fingerprinting packets, all kinds of things. So we're excited for that. So that's one that you bring your children to. So spread the word. We'd love to have tons of kids here for that. January 22nd is our third annual maybe, Community Resources Fair. I have to check. They all sort of blur together now. So what we do at that point is it's just come as you please. And we'll have vendors set up all around this very room for you to talk to anyone who's of interest to you and your family. Whether it be special needs summer camps, whether it be the Office of Vocational Rehabilitation, whether it be a law firm, we'll have all sorts of resources in the community. And also if you as a parent have a connection to a resource and you'd like to share that with me, I'd be happy to share it with U-PRISE as a larger group. In March will be our final meeting, and this one will be geared towards secondary age students, so middle school and high school. And we're going to be talking about those tough topics of learning how to drive for kids with special needs, and we'll have hopefully some special driving schools come out, in one of them being the IU. And also we're going to talk about volunteer and employment opportunities for our older students. So those are our U-PRISE meetings coming up. We also have an advisory committee that meets basically once a year at this point to just talk about how we think everything this year went and what topics we want to have next year for our speakers and our session. So if you're interested in that, you can email me and I'd be happy to include you. Just so you know, also all of our resources are posted on our website. If you go to the speaker series, the last 3 years worth of meetings are here. So if you're really interested in a certain topic and you're trying to find it, we try not to repeat topics too often. So if you go back to 2016, 17 and you're really interested in, say, social skills, if you clicked on that link, you'll see the presentations from the people that spoke that night, and there's also a video link so you could actually watch the video of the presentation. So everything's there from the last 3 years. So it's really a great resource. And so this meeting is also being videotaped. That's why Ryan's here from technology. And then we'll get this, it's not live, but we will get it posted on the website in the next couple of days. So if you know of someone who, after you leave here tonight, you're like, oh, I really wish so-and-so were here to see this, you could tell them to just check out the website. Okay? Did I forget anything? Yes, let me introduce some of our guests that are here tonight. One of the big purposes for coming is networking. We'd really like you to meet other families who are maybe in the same school as you, maybe have a child with similar needs as your child, and also to meet some of the administrators in the district. So I introduced myself, I introduced Dr. Ryder. Also here is Dr. John Sandville, who's our superintendent. Cliff Beaver is here. He's our principal of Pecopson Elementary. And Steve Dissinger is here. He is our principal at Patton Middle School. And one of our teachers is here. Our middle school autistic support teacher, Sarah Esberg, is here. All right, and then I see we have families from all levels, so that's very nice to see tonight. All right, so then we'll lead into Steve Potts talking tonight about a bunch of special needs stuff, all that tricky area. So I'll take this down so it's not distracting, and then we'll let you take it away.
Thank you, Shannon.
Yes.
Thank you for having me, and thank you everybody for coming. When I talked to Shannon about possibly doing this talk, I mentioned a couple things, and she said, yeah, let's do them all. Let's go. So I said, okay, let's do it. So the two handouts that I had up there were around, the one was around special needs trusts and the ABLE account. And the other one is regarding guardianships and powers of attorney. I was going to start with the special needs trust and ABLE account one, just because I think that would cover almost everybody. If you have somebody in your family that is receiving governmental benefits or is likely to receive governmental benefits in the future. And I guess I should step back talking about the governmental benefits, depending on what type of benefit you would be receiving. Whether the individual would have assets in their name could affect whether they would keep receiving that government benefit. So what they call that is it's a resource-based benefit. And a resource-based benefit says, all right, if this person's assets are over $2,000, they aren't going to be able to access this governmental benefit. So depending on a person's income, the person's asset, that will determine what if they're able to receive that government benefit. The whole idea around special needs trusts is the government didn't want families disinheriting their children because if the child receiving SSI, medical assistance, waiver funding, the government saw that families would say, all right, we can't give our son who's receiving these resource benefits, them an inheritance under the will, so we're going to give it to our other daughter or something and say, daughter, take care of our son if you can. Unfortunately, what would happen is daughter would get in a car accident, get sued. Daughter would get divorced. Daughter maybe didn't give the money over to brother when she really should have. So what the special needs trust is, it's a mechanism so that you can leave assets to your special needs child or somebody else, grandma, grandpa wanted to leave assets to the special needs trust. They could continue to receive government benefits, and whatever the amount that was in the trust would not count as a resource. So if they're receiving a government benefit where their assets have to be under $2,000, mom and dad pass away and leave $1 million to a special needs trust, they can continue to receive those benefits. The trust is not counted as a resource because what the government says is it's not their money. It's not their asset. They're a beneficiary of it, but we're making an exception here if it meets the requirements to be a special needs trust. So that's kind of like the quick overview of the special needs trust. And I guess I didn't say, if anyone has any questions while we're going along, please raise your hand. I don't mind hitting. If you have a question along the way, just let me know. So there are 3 types of special needs trusts. And depending on what type of special needs trust is set up, that will determine basically what happens at the end, meaning the beneficiary passes away, what happens to the assets in the trust. Most families that are coming to see me who, like I said, have a child who is receiving government benefits, or it's very, very likely that they are going to be receiving them in the future. Maybe they could be 5, they could be receiving waiver funding, they could be receiving any type of government benefit that ultimately when they turn 18, the government's going to start looking at their resources and they're going to say, wait a minute, you can't have all these resources. So, we would be setting up a special needs trust for families at 1, 2, 3, 4, whatever, You know, if it's clear and we can do it now, we can set up a special needs trust, or very early for the child. And the first one that we are likely to set up is the special needs common law special needs trust, or it's called a third party special needs trust. And that is basically mom and dad are not leaving the assets to their child, they're leaving it directly to this trust. So it never becomes the child's assets, and it works just like I've described the special needs trust. Whatever goes in that trust is not going to be counted as a resource. So they will continue to get the government benefits that would be available to them. The big benefit of setting it up early is that the family gets to decide what happens to those assets when the beneficiary passes away. So let's say there's other children. We can have those assets go to the other siblings. When the beneficiary, special needs child, passes away, it can go to whoever the family decides that it wants to go to. So that's the real big benefit of the third party special needs trust that we set up. The next one is what's called a special needs payback trust, and it's also called a self-settled special needs trust. I kind of see it as the uh-oh trust, like uh-oh, we didn't plan, or uh-oh, something happened that we couldn't have planned for, and we have to do this payback special needs trust. And basically it acts just like the third party special needs trust in the fact that the assets that are in the payback special needs trust are not counted as a resource for the child, so they can continue to get government benefits. But when they pass away, we have to pay back the government for the benefits that they gave to the child or adult. So mom and dad didn't set up the third party special needs trust. They just leave them as a beneficiary of their estate. And I get the call saying, uh-oh, they're on government benefits and this is going to knock them off. So, okay, let's do a payback special needs trust. We get it approved by the Department of Human Services and Social Security, and we can move those assets into a payback trust so that the person can keep receiving their benefits. But unfortunately, it's likely going to be paid back to the government. We're not going to get that chance to leave it to another sibling or a niece, nephew, however the family would have wanted it to go. This would cover an automobile accident, grandma and grandpa just leaving that in their will, and we didn't say, wait a minute, don't leave it to Johnny because Johnny has benefits. We should have set up a trust and had grandma and grandpa do it directly to the third party trust that we set up. And then also we see it, people would set up the special needs trust. They have it under the will. They're happy. They're we planned, and then the lawyer or whoever didn't say, you got to change your life insurance policies. You got to go over your retirement plans, because if let's say you haven't filled out the beneficiary form, well, by the plan's rules, it's probably likely going to end up to a child directly, or you don't think about it and you set it up when they were young and you just named my children or something like that. Well, it's going to go to them, and that's an uh-oh type of situation, because now we have to set up a payback trust, and it could be a lot of money that's going to go back to the government rather than going to another child.
Even if you had the special needs trust set up separately?
Even if you, right, and you didn't name it, they're not going to allow you to go, okay, sure, yeah, just put it over there. They're going to say, no, that goes to the individual who's getting those government benefits, so you got to do a payback if you really want to keep that benefit. The third type of trust is what's called a pooled trust, and basically that goes to when you set up a trust, you need a trustee, and the trustee is the one who's going to oversee the assets, determine when distributions should be made, for what purpose. They're going to be filing tax returns. And sometimes families didn't have somebody that they trusted or that they thought could do the job. So these pooled trusts came in, they're nonprofits, and they say, all right, we'll act as the trustee, and we'll manage the assets, we'll determine the distributions. But when the individual passes away, the beneficiary passes away, we're going to keep whatever's left in this pooled trust for other individuals with disabilities. So if someone runs out of their money, their account with the pooled trust, the thought is, well, if somebody had passed away and there was still another $100,000, we'll help out this person who ran out of their money. Usually we see that with, like I said, somebody who really can't figure out who to be a trustee. So they go to somebody like this, and probably lower assets, or they really don't have any other children, and they would rather just benefit other people with disabilities. So that would be where the pooled trust would come in.
Who designates it as a special needs trust versus a regular trust? Is it just specific language about the disability? Is it just the language that's in it?
Yeah, the difference between like a special needs trust and just a regular support trust is, yeah, it's just the language that Social Security and the Department of Human Services want to see in that type of trust. But once you have that in, they're going to go, okay, that's what it is. But if we have people who say, oh, well, this is the special needs trust, and we just kind of review it, and we're like, it's not conforming to what it has to be. It's just a regular support trust, and that's not going to do the job, because a regular support trust would still be considered the asset of the individual, and would make them ineligible for benefits.
So the assets aren't included as resources, but the one line there in the first page, it talks about there's certain government benefits where, say, your income's over $2,000, unearned income's over $2,000. So the income coming out of the trust is going to be deemed unearned. So that, even though the asset is not deemed a resource, the income could be deemed a resource. Is that correct?
The income created in the special needs trust could stay in the special needs trust and just be taxed within the trust.
So you just, instead of distributing out.
Correct.
You just
If you do distribute it out, you're right. That income could be then put to the individual, which if they are on a benefit that has income restrictions, that could be a problem. And that's when you would say, all right, let's keep it in. Yeah. I'm sorry.
A month or a year?
Oh, they would be looking at it that monthly. Yeah. Well, a lot of the other questions that people come in, well, how much should I fund the special needs trust? And that question really revolves around what's the family dynamics. We have people who do need a lot of extra pay because the government benefits are not providing enough. And in that situation, then we would say, well, you may have to fund that a lot more than you were thinking. But then we have other individuals who come in and are saying, with the Social Security and the waiver funding, it's really supplying a lot of the benefits, and we're not sure if we fund this with $500,000, it's just going to sit, whereas my other child is going to get married and have children, and they're going to go to college. So, it's really particular to the situation how much you would want to fund that trust. But you can fund that trust with, let's say, your own personal assets. You can fund it with life insurance. Like I said, grandma and grandpa can write a check to the special needs trust. So there are different ways to fund the trust. I would say that, inheritance and life insurance policies are likely used the most in these types of situations to fund the trust. And what can the trust be used for? It's really to supplement those government benefits. So it's a really wide gamut of what you can use it for. Social Security or anybody who would be interested in what the funds would be used for. They're really just looking for that it's for the beneficiary to, make their life better, to supplement their government benefits. What they say is that they really don't want it paid for food or housing. Once it's used for those things, then that could affect the government benefit. But otherwise, you can use it for many, many, many things. This talk that I gave was using the ABLE because the ABLE was just coming out. I think it was around 2016, 17. And I think people were like, oh, we don't need special needs trusts anymore. We can just get an ABLE account. And the ABLE account is a little different than what a special needs trust is. The ABLE account was designed to allow individuals with disabilities who were maybe working or maybe not even working, but wanting to save money, and they had this $2,000 limit on what they could really save for. So if they were saving to take classes at a college or save money to go on a trip or whatever, there was really no mechanism to do that. And really even saving for, we had someone working at Wawa, and she just really wanted to save for retirement almost. And just by getting the Wawa retirement, it was going to be affecting her benefits. So the ABLE account was really designed to help these individuals in those types of situations to save money. And the big benefit of this is that it grows tax-free, and it does not count as a resource for the individual. So again, that sort of acts like the special needs trust, but there's a lot of differences that make it not as useful. I don't know if that's useful, but I would say it doesn't take the place of what a special needs trust can do. So the ABLE account, each state has their own ABLE account. It acts like a 529 account, so that you just go online, you set up an account, and then the beneficiary can set up the direct deposits or whatever, so that the money goes into this account. Somebody can also contribute on behalf of the beneficiary so that the monies go into the account. But there is a $15,000 limitation each year that the assets that can go into that ABLE account. So per person, per the beneficiary. So mom and dad can't put in 15 each, right? So only $15,000 a year, and that's the limit that can go in. But that that $15,000 for that person working at Wawa was just, huge, because maybe they only had $2,000 or $3,000 that they wanted to, but that was able for them to then continue getting their government benefits that they needed, but allowed them to save some money. So I won't get into what it can be used for, because there's some regulations around that, but you can see that it's similar to the special needs trust. And what I guess how am I going to say this? They want it to grow, but they don't want it to grow that much. Once you hit $100,000, they're going to start to look at your other assets for certain benefits, so that if you have $2,000 in your name and you have this $100,000 in the ABLE account, anything over that $2,000, they're going to start to say we're going to start affecting your SSI. So the $100,000 after that is going to be counted as a resource and could affect your benefits. So that's something that really has to be considered if they are receiving these resource-based benefits. They could be receiving, just say, an income-based benefit. So they're really looking at their income. They're not really possibly looking at the resource. So that may not be a problem, but that's something that would have to be watched. They do allow now for 529s to be rolled over into ABLE accounts, where we've had individuals who we thought, say, would be going to college, so they were saving for 529s, and then it was, okay, this doesn't look like the road for them, but we don't want to kind of pull it out and pay tax and penalty on it to use it. So you can roll over $15,000 a year into the ABLE account, which is a nice benefit. The other benefit, because we talked about the growing tax-free, the other benefit is that you get a deduction for the contribution to the ABLE account if it's a Pennsylvania ABLE account and you're a Pennsylvania resident. So if mom and dad do want to contribute $1,000 to their son's ABLE account on your PA 40, you'll see that you can actually deduct $1,000 on your tax return. Yes.
I'm sorry if you said it already, but can a disabled person or person with a special need have a standard 529? Is it counted as an asset? Will it go against the possibility to create a SNT or an ABLE account, or am I missing everything?
So you're saying you would want to,
Can you have an
like have a special needs trust, have an ABLE account, have
and have a 529?
yeah, the
Standard one, that is not for any special need. If you create it's the 529, it's the one for education, right?
right, correct.
If you had created one and your kid is actually special need, do you need to get out of it so that he can or she can have a trust or an ABLE or the benefits? Or
Yeah, I believe they're going to count the 529 as a resource. So you could change the beneficiary. You have another child, just to change the beneficiary. Or you could start rolling it over $15,000 a year into an ABLE account. Now, an ABLE account, let's say they're not going to go to college, but maybe they could go to a trade school. Maybe we could hire a work coach to go with them. The ABLE account can pay for that type of things.
So 529 assets are included as resources.
I'm like 99% sure that they would be counted as a resource. Yeah.
I believe that they are.
Yeah.
Can you contribute the $15,000 to a 529 and an ABLE account in the same year, or is it one or the other?
For the same individual,
Yes.
I don't see why not. I don't. The deduction for Pennsylvania purposes, you might not be able to take both. They may limit that. But I don't see why you couldn't if you wanted to.
I think if one person gave both 15s, then I think you would eat it to your exclusion.
Yeah.
I think that, so, but if it's a husband and wife, then you could give 15.
Why they take part time in the tax, right?
But it's the annual, it's the annual gift tax exclusion.
So you can take it from your estate tax there.
You can take it, yeah, you eat it to your exclusion. Correct.
Yeah, the 15 is tied to the gift tax exclusion.
If I can make a comment. About the 529 plan, if you do have multiple children, doesn't matter how much you have set up, you can transfer the whole balance over to another child if you need to, at, I think, any time, one time during the year. So if you need to move the funds, it's not going to limit you if it's included in the assets.
So the ABLE account definitely has its benefits. Sometimes people, are wondering which they should set up. I think if the situation shows that, the individual would like to save some money, or they have this money. Sometimes I get the call, they had a birthday and we got all this money. Before it was kind of like, well, maybe you should just keep it in cash, or maybe put it in mom and dad's account, But now with the ABLE, you can actually just start funding that with a little bit of money, and maybe later on when they're 20, 25, 30, they'll have some money saved and they'll want to do something themselves, to decide on what they want to do. So it definitely has its benefits, but it has not replaced the special needs trust. If there's going to be an inheritance of bigger funds, I mean, if you got $100,000 and this is limited to $15,000 a year, you're not going to be able to take an inheritance and start using the ABLE account.
And then the ABLE was a payback option. It's not something that could then be, like, for the trust. You could also have a third party where it could be sent to them if that individual would pass.
Right. That's a good point. So the federal law says that states may go back to the ABLE account and get paid back for the benefits that they provided. Pennsylvania said, we're not going to do that right now. So they can still go after the individual's estate right now. So if the ABLE account just goes through the individual's estate, then Pennsylvania would then be able to go after those assets to get paid back. I have not seen yet how Pennsylvania is acting on these accounts, but I'm going to guess with how government is, they're looking for money anywhere, that they're likely going to look at these accounts and start going after them to get paid back. So that's why I don't see it as a mechanism like a special needs trust.
One more question. For ABLE account, does the child make decision with your money how to spend the money, or your parent?
Good point. If the child is over 18, they have to set it up unless they have a power of attorney or a guardian, and then the guardian or power of attorney could do it. But with this account, the child has the authority and ability to take the money out and use it how they want.
If you set up a special needs trust or an ABLE account for a child and ultimately they don't qualify as disabled for SSI, etc., then what happens to in that situation?
Yeah, we see that a lot, and we've been writing the wills now to say if they are receiving resource benefits, or it is likely in the executor's opinion that they will, then it would go this way to a special needs trust. If they're not, and it's not likely that they will, maybe let's just put it in a regular support trust. But let's say, like you said, it's set up and grandma and grandpa just leave $100,000 to it. And later on, it's determined that, okay, we're not going to really be using this as a special needs trust. There is no penalty, but basically it's going to be looked at as just a regular support trust, because the government's not so concerned, because it's not like it's growing tax-free. It's a trust, it's going to be taxed. But they're not so much concerned because the person isn't receiving resource-based benefits. So they're like, that's not really bothering us if it's just a regular support trust.
There's no harm, no foul to put it in a special needs trust, and if the child becomes an adult and doesn't get any benefits, there's no harm, no foul.
Right. I mean, I think if it's later determined that, they're not going to get benefits, then okay, maybe we just make it a regular support trust, and let's adapt now, because we know a lot more, how we write this regular support trust or something like that. But yeah, if it happens and nobody changed it, the trust will still work as a trust. It's just not based around getting government benefits.
And what about the ABLE account then?
The ABLE account, to establish it, it does have the rule to just even establish it, that the person is disabled. And I don't know if I have the definition of that in here, of what they consider. as disabled.
Would an autism diagnosis at the age of 3 automatically qualify you
I think if
for
it's,
government benefits?
I think, well, I think that there, it could possibly, you could get benefits at this point with that diagnosis. And I think that diagnosis would also allow an ABLE account to be established.
Do you have to establish an ABLE account in the state where the beneficiary resides?
You don't. So again, like they've done it like the 529s, you know, you could open up in Iowa. I forget, there was like a real popular one years ago, like Idaho had low fees or something, I don't know. You could set it up in a different state. You wouldn't get that tax deduction for Pennsylvania if you did it in another state though. They want it in their own PA.
But if you establish one in Pennsylvania for someone in Connecticut, you get the deduction, but it's also okay.
Right.
from this.
Correct. Yes, because you're a
When
Pennsylvania.
you're talking about the payback,
Mm-hmm.
the Pennsylvania one payback, what does that mean? Payback for what, the tax on the interest of the growth? or what?
Sorry, yeah, I should have specified. So it's payback for the benefits that they gave the individual during their lifetime. Well, your Pennsylvania benefits, like waiver funding, even though that's federal funds, you're getting that through the state. The state is doing those funds, and they're going to look at that as wanting to get paid back for.
So in the scenario where we were talking about a beneficiary in Connecticut for a Pennsylvania-based fund, would Pennsylvania look to the benefits paid through Connecticut?
I think that it's ABLE account, right? You were saying in PA. I think Connecticut would come calling and say, "Hey, federal rule. I don't care what Pennsylvania's rule is. Pennsylvania whether they want to get paid back or not. We're Connecticut, and we want to get paid back. So send it this way." Yeah. And I don't know what Connecticut's rule is, but I was surprised what Pennsylvania said. Oh, we won't go after that, even though we'll go after the estate. I would have thought that they would have been a little bit more aggressive on trying to get paid back, but
But that's on the estate.
that would be on the estate, yeah, to get paid back. Yeah. So, any other questions on the special needs trust type of estate planning? Yeah.
Just thinking about, this might be a little bit higher, generation skipping tax. If you make a contribution to an ABLE account or to a special needs trust, does that exclude you from having to pay generation skipping tax on it?
So let's say ABLE account for granddaughter. Yeah, as long as it's under that 15, I don't think they're going to, and it has to be, I don't think that they're going to have you file anything special to qualify that for the generation skipping.
How about into a special needs trust? Let's say somebody left $100,000 into a special needs trust. Is that excluded?
You know, I'm not positive, but I don't think that there would be, I don't think that there would be an issue on that, because if the trust went directly to them, I guess there could be a situation where it's set up for granddaughter during her lifetime, but then it would go to great-granddaughter who has special needs or something into a trust. I suppose it could get into generation skipping, but I think on the wide view of it, high level, I don't think there would be.
Forgot to tell you, Steve, we ask good questions.
Yeah, that's fine. You know, I didn't repeat the questions, so I got to remember to do that. So yeah, I mean, the special needs estate planning is kind of the majority of the estate planning that we do when families come in. And again, we're looking to do wills and this third-party special needs trust. Obviously, we don't want to pay back the government if we don't have to. But the special needs trust works with the wills. We want to have the wording correctly, that it goes to the trust, and we also want to address life insurance, retirement plans, annuities, anything that has some type of beneficiary on it, just because we don't want to forget about something like that, because we've done everything that goes under the estate, under the will. But a life insurance policy that has a beneficiary designation to my children, that's not going under the will. That goes directly to my children, and that could mess up the planning that we had done. So that's why we want to, when we meet to do the estate planning, we're going to go over all of that to make sure we don't miss something. So I guess we could move to the next topic, which would be guardianships and powers of attorney for adults with special needs. So first in there is adults. In Pennsylvania at 18, you're an emancipated adult. No matter what the situation is, I guess there could be a different thing when you're looking at child support, but overall, legally, you're an emancipated adult at 18, and that's when you can start signing powers of attorney if you wanted to, and that's when a parent could get guardianship because they were the guardian until age 18. Now at age 18, they're an emancipated adult. There may be a need to get guardianship for them. Guardianship is a court process, and basically the court will hand down an order saying, we decree that this individual or these individuals are the guardians of this other individual. And usually when a family comes in to do a guardianship, it's about, depending on which county you're in, about a 2.5 month to 3 month from start to end timeline. Getting to be a guardian, you would become a guardian of an incapacitated person. And what they define as an incapacitated person, I have that just on the page 1. It's a person whose ability to receive and evaluate information effectively and communicate decisions in any way is impaired to such significant extent that he or she is partially or totally unable to manage their financial resources or meet essential requirements for physical health and safety. I was saying this today. Some of the laws are more geared towards the elderly. Grandma, mom has dementia, Alzheimer's. They never signed a power of attorney. We need somebody to take over their affairs, make medical decisions, sell their house, whatever needs to be done. That's where the guardian could be appointed by the court and do those things. Same type of thought would be on somebody who is special needs and is incapacitated, and we would need somebody, parent, neighbor, whoever, has an interest here to see that, look out for the individual to be named guardian by the court. There's different types of guardianship. You can get plenary or limited guardianship. Plenary is full guardianship, and limited is obviously limited. So you can have a limited guardianship just over their health care matters. You could have a limited guardianship just over the financial piece of the person. And that gets into the other difference of you can get a guardianship of the estate and you can get a guardianship of the person. And the guardianship of the estate is basically their finances, their assets. The guardianship of the person is where they're living, what type of medical decisions have to be made. So they're going to look at that. The court's going to look at that as two distinct things. So, like I said, you could have a plenary guardianship over a person and of the estate. You could have a limited guardianship just over the estate, and it could be just over their real estate. Maybe they have no other assets and some real estate just needs to be sold. You could do that. The court could just say, all right, we're going to limit it just to this specific type of need. So when you petition the court, you're going to lay that out. What do we really want to get? I would say in the majority of times for individuals with disabilities, if we're doing that, piece of the planning, it's likely going to be a plenary full guardianship over the estate and the person. Yes?
Can you have both, like for example, my aunt goes to Overbrook School for the Blind, and right now my grandmother is the full guardian for her, but, if I wanted to become limited, or, limited guardian, but we wanted to complete that before my grandmother passes, is that an option to have too, where you have a full guardian and then a limited one set up?
Yeah, well, it could be if you're a plenary guardian of the estate and then a limited guardian of the person or whatever, you could have two individuals doing two different things. You could. I'd say the court usually likes it to be one person or a co or something like that and not break it up like that, but they could do that if someone's like, hey, I'm not good with assets. I'm not really looking to look into the financial piece, but I know healthcare. I want to make sure that she's getting the healthcare needs that need to be done. Then yeah, we could have two different people.
Or can you just set up the limited guardian after that person passes? So after my grandmother passes, I'm able to become a limited guardian, being a relative, to cover her, like if I wanted to be in charge of her medical.
Right. Yeah, you could. Yeah, I think if the court said, if there was a plenary guardian and that guardian died, I think they would want someone to replace that, not just with a limited piece. They would want to have somebody, do that role. But if the plenary was just over the estate, and let's say you just wanted to do limited over the person, I think you could do that. Who can petition the court? It's basically any person who has interest. But obviously the situation I see more is parents who at age 18 decide that a guardianship is the right path, and they say, we want to be the guardians, we're going to be the people to petition. But we also get the call, no guardian was set up, the individual is 68, and mom and dad just passed away. There's no other siblings, but a neighbor really has stayed involved and would like to, continue to stay involved in the person's life, and they could be named the guardian. You file in the county that you live in. I don't know if I said that. So if you're in Chester County, that would be the county that you would file in, and the court that you would file in is what's called orphans court. So don't know why they have that, but there you go. Procedure, I think I talked about real quick. The procedure is it's going to be about a 3-month process. So people come in, they have all the information, let's say, or we go over it. We do up a petition for the court laying out the facts. Who wants to be the guardian? Who's the alleged incapacitated person? What's their financial assets? What's their healthcare situation? We lay out all the facts. We file that with the court. We usually get a court date in the next 2 weeks after it's filed, and that court date's usually about a month and a half out. And with all that going on, it's probably like a 3-month or so process to get that all done. Yep.
Who would make decisions in the interim?
So if there was an emergency type of situation, so that I think that goes back to the question in the end of do we need a guardianship or do we not? Why are we doing this? There are mechanisms for an emergency guardianship. So let's say we are on the path of doing one, but there becomes a crisis that needs to be taken care of. You can petition the court on an emergency basis to get a guardianship for 72 hours, and you can extend that if needed with the court. And that guardian would be able to make those decisions in that time frame. So there is a mechanism to do it, but we also have people who know that there is something that health-wise could happen after age 18, And the courts, at least in Chester County, has allowed us to file early so that we get that court date like right around age 18. Now, when you do file the petition, oh yeah, sorry.
Just before you move on the timing, can you anticipate that sort of decision prior to age 18? I'm sorry if you've answered that already. Can you prepare all this so that it kicks in at age 18 if necessary?
So yeah, you can get it. We can petition the court earlier if it seems like we don't want any lapse there. But the court date couldn't happen until after or on the day of age 18. Lots of times families will go to the same doctor and the doctor talks to them and it's not a big deal, even though the individual's, 19, 20, 21. And then all of a sudden the doctor retires, or no, we can no longer go to that practice, and we go over here, and all of a sudden they're not talking to me. All of a sudden they're not telling me information because of HIPAA laws. That's where sometimes we'll get the call, we didn't need it until we needed it, and now it's something that we need to get done. But I guess back on the filing of the petition, the new rules now, this past summer, they passed rules that you have to have a criminal background check as a guardian. And there would be a statement on if you've ever filed bankruptcy. This was to protect in the situation about 3 or 4 years ago. In Philadelphia, there was a woman who was named guardian of all these people and was just stealing their money. And the courts were not paying attention enough, and I think they got really scared and realized that they had some liability here, and so that's why the criminal background check. Also, with after you do become guardian, you have to file annual reports. So if you're guardianship of the person, you file an annual report to the court, basically describing what's going on with the individual. Where are they living? Has there been a change in circumstances? Any medical information the court should know. If you're also guardian of the estate, you're going to file that other report, and you're going to lay out what are the financial situation. Did anything change? Just so now that the courts want to make sure they're following what's going on. Here's the emergency guardianship we sort of talked about. Obviously, an emergency guardianship is a lot more expensive than a regular guardianship because we have to really drop everything and figure it out how we can get the guardians appointed quickly. Most of the time, the emergency guardianship is situations like the maid got mom's bank account online and is withdrawing assets or something like that, and we need to act quickly because the bank won't talk to us or something. Or it could be a mental health crisis where we need to get somebody appointed because with the crisis going on, somebody needs to make those decisions, and that individual is not able to make those decisions at that point. So that's usually where the emergency guardianship kind of comes in. I kind of won't get into all of the procedural things, but the evidence presented at the hearing, how does the judge know that somebody fits that definition of being incapacitated? They're not medical individuals, most likely. And what we're gonna file is what's called a doctor's report, and that basically is the doctor going through what the state wants to hear to qualify this individual as incapacitated. So it's about a 7-8 page document that if your own doctor could do it, if they have the ability to do it, if they have the background to diagnose somebody, you could also go out and pay somebody to do it, but usually we try to get the doctors that the individual is already seeing to fill out this doctor's report and file that with the judge, because the judge is going to look at that and make their decision based on a medical diagnosis, not bringing the individual into court and just saying this person's incapacitated, they want to see a doctor's report on that. So, the final hearing, depending on which county you're in, the hearing could be 30 minutes. It could be 5 minutes. I'm being taped, so I'm not going to criticize any county out there. But you know, and it could depend on which judge you have too. But it's usually I would say it's about a 15 to 20 minute or 15 to 30 minute process, and it's usually very friendly. Usually, when you're getting going through that process of getting the guardians appointed, and you know, usually if we're having parents do it, one parent will do most of the talking. Lots of times they don't even have to go up on the stand. They just talk from sitting in front of the judge. The judge will want to hear from the other spouse. And usually we like to have, if it's possible, the individual there so that the judge can see the situation. And, you know, if it's mom and dad, it's pretty easy. It's harder when it's, you know, Uncle Joe who, you know, lives in a different state or something like that. Then we're there a little bit longer, I guess, just so that the judge can size up the situation and make sure, you know, they're not missing something here, and we're looking out for the incapacitated person. So, even though you get a guardianship per the statute, the incapacitated person should be permitted to participate at the maximum extent possible in decisions that are made. So we have had it. There are mechanisms to address where a guardian is just not listening to the individual. And it's quite clear that the individual can express their desires and express that they are not being listened to. And we can go back in front of the court and say, look, Your Honor, here's what the individual wants. In our opinion, they're not being listened to, and the guardian should be listening to them. And most likely the judge could make a decision and say, hey, I'm putting an order down that you need to listen to them. This is what they want. Let's get it done. If the person is not listening, in a lot of ways, they can be removed. That doesn't happen often, but it does happen. And I think that gets back to, we haven't talked about power of attorney, but when people say, I'm afraid of doing a guardianship because it is taking rights away from the individual. Once the guardianship is in place, they can no longer sign contracts. You know, the decision making when you go into the doctor's room, the doctor's going to listen to the individual, but ultimately when you sign the release of liability, they're turning to the guardian and saying, you know, are we doing this or not? So, although it is a very, very serious, you know, legal procedure, and that it does take the rights away from the individual, there are mechanisms to ensure that the person is being listened to, that their wants and their wishes are not dismissed, and that the court can address that in different ways to make sure that they are listened to. There's bond. Bond is more for, you know, grandmom has, you know, $5 million and all nieces and nephews come out of somewhere saying, we want to be the guardian, we want to be the guardian. You know, that situation, they're going to have the who they appoint as guardian to go out and get a bond. And a bond is going to a bonding company to pay for basically insurance. If I become the guardian, I take the $5 million, the bonding company is ensuring that they'll pay that back. And there's a premium to pay to get that insurance. Now, obviously, you shouldn't just do that and so the bonding company can pay because you'll be prosecuted criminally, but that bond is there to protect the incapacitated person. When there's parents and there's really no assets, you know, the typical situation, we need to keep our assets under $2,000 because they have SSI, they have waiver funding, or waiver services. the court's not going to require mom and dad to go out and get a bond in that type of situation. Yes.
Can you, it's this, maybe no, I said at a certain time, but if in the future, it appears that somebody can give these 5 million to the disabled person, can it be stated somewhere that if that case occurs, then a bond should be required, or the watership should be reconsidered?
So they don't have the 5 million now, but they get it later, you're saying? Yeah, right, because the guardian, right, yes, the guardian, because let's say their first annual report, they list $10,000. Well, the next report, they're going to list 5 million, and the court's going to go, wait, whoa, because they're going to look at both reports that are filed. And in that case, they're probably going to bring the people back and say, wait a minute, this is a different situation. We need to address this. The powers and duties of the guardian, you can go through that. I think what's important, though, is that because the powers are going to be depending on, is it plenary, is it limited, is it over the estate, is it over the person? It could be a wide gambit, but it would be dependent on, what type of guardianship it is. But there are certain things that you do need to go back to court to get it. They likely won't give that right away, and that's on page 9 at the bottom. And it's things like abortion, sterilization, psychosurgery, those types of things. The court wants you back to address that to them, and most likely you won't be able to get them at the original guardianship hearing unless you have unless there's a situation, obviously, at that point, then you could address it with the court. And then finally, there is a mechanism to remove the guardian if, in fact, they're not doing what's right for the individual. And then we get to powers of attorney. You probably have heard of powers of attorney. You may have powers of attorney for yourself. Because a power of attorney, you get in an accident or something happens to you, you are early Alzheimer's, I don't know, something, who's making those decisions for you? Lots of times depending on the situation, lots of times they're going to look to the spouse and say, hey, what's the decision? With HIPAA laws, lots of times they shouldn't be just telling the spouse certain things, but they do. We all know it. But naming a power of attorney allows that person to get access to that medical information, to make decisions for the individual. So, even you can have a power of attorney. Mom and dad, your mom and dad or whatever could have a power of attorney, probably good for the elderly to have their powers of attorney. But for here in this situation, the powers of attorney that adults with special needs could have would be a durable general power of attorney, which is basically a financial power of attorney. So if they do have assets, or even if they don't have assets, because we can modify the power of attorney. Let's say they can't deal with the government benefits. Obviously, you probably know getting on the phone with Social Security or somebody like that is very frustrating, and that's maybe not something they can do. They could sign a power of attorney. You could be the power of attorney to deal with that. We could put that in there. Maybe they are at a college or something where they can't talk with the administration for whatever reason. We can put in that their power of attorney can discuss their grades or discuss other educational topics with that person. So we would be looking at a durable general power of attorney. We'd be looking at a different document called a healthcare power of attorney. Again, naming somebody to make healthcare decisions for you, getting access to that medical information, making those decisions. And usually you name somebody, a primary person, then you try to name a backup if you can. But this allows the individual to have somebody, because they're over age 18, mom and dad at a certain point can't, even though maybe they're at a family practice that has allowed mom and dad to make decisions, they've hit a roadblock because a new doctor came in, there's new rules, or they've moved practices and they're saying, no, we can't share this information with you. And then you'd have to go out and get a medical or a healthcare power of attorney to continue that relationship to getting access to that medical information. And then lastly, there's what's called a mental health declaration and power of attorney. So that's fairly new, and it really allows the individual to lay out what their preferences are, what their wants are, if in fact they hit a crisis mode that has happened in the past, that they want it addressed a certain way. And I think that really does empower them to have someone do what they would want, because they are now in crisis mode where they can't make those decisions, and they've laid out their preferences and wants, and that person can step in and be their advocate and make sure that they are protected how they would want to be protected. So that authorizes the agent to consent to do different things. And I have seen the benefits of that many times since it came out. If we can sit down with the individual to go through different scenarios, and they can say what they would want in those situations, it's very helpful. It's very helpful. So the big question is, well, do I get a guardianship or do I get a power of attorney? Tell me the answer, Steve. And I say, I can't tell you the answer because it's really dependent on your situation, what your wants are, what your child or adult child is facing and what they want. Lots of times what I see is, okay, child's living at home. They do work in the community, but they're coming back every night. I'm driving them there. I'm driving them back. It's a very controlled environment, and they don't have a power of attorney or a guardianship. Well, we're at the same family practice where it's driving them to work, coming home, and I don't really feel like we need to do anything. But what I would say is, well, let's do something. Even if you don't want to go down the guardianship road for whatever reason, let's get a power of attorney in place then, so that if something happens, you don't want to do the emergency guardianship because that's going to be really expensive if we have to go down that road. Let's at least, if we're not going to do guardianship, let's do a power of attorney just so that they're protected. Someone can make decisions if something happens to them. And that's usually going to be my advice. But if a family comes in and they just know, in a situation where they're nonverbal, they have no concept of money, and we really have to step in this situation and do a guardianship because there's going to be healthcare decisions that would have to be made, and we know they are not going to understand, or maybe they can't even sign a healthcare power of attorney. Then we're going to do the guardianship and just get that going. So, again, depending on your situation, after we sit down and talk, you're going to decide what's going to be best for your family, whether it's going to be the guardianship or the power of attorney route. So, does anyone have any questions? Yeah.
This one's more so parent-related, something that just happened. How easy or difficult is it to just do a medical power of attorney for somebody who's been getting confusion and had to go to a hospital due to a delirium caused by a UTI infection?
Yeah.
Because they'd have to be coherent to be able
Correct.
to sign the form, so this would be after the episode that's happened recurring time.
Correct. Right. So, as the attorney would want to make sure that they do have the capacity, at least at that point, to understand roughly what's going on. In that situation, what I would be saying would be, okay, I'd want to talk to them. Are they comfortable with this? Do they know what they're doing? let's say you're the only son. I don't even know if it's your mother. Let's say it's your mother. Are you the only son? Sure. No, there's actually 4 boys, and this one was my healthcare power of attorney last year, and I switched to this one, and now it's going to be this one, and now then I'm going to size up the situation and go, all right, what's going on here? Are they playing with mom here and trying to take advantage of the situation? So, but I think what you described with, she's had that problem, but she's kind of coming out of it to understand what she's signing, then I wouldn't see that as a problem to get that done.
Problem with this one is they went into a facility last year and we couldn't get them to take her to the hospital because we didn't have the authority to tell her to take her to the hospital. And the aide didn't see the same signs of the confusion. It took 5 or 6 different people. The facility didn't have the ability to do it. So she sat there for a few weeks with the infection and nobody could do anything.
And that got a lot worse for her. Yeah. The healthcare power of attorney would have been perfect, to take over in that situation so that you'd be able to have the authority to make those types of decisions. I know we covered a lot. Any other questions, though?
I think Steve will stay for a few minutes.
Oh, yeah.
Too, if anyone wants to ask personal questions.
Yeah.
Come up. So, I think we'll end for tonight then. Thank you very much for coming out, and feel free to network with who's here before you leave again. And our next U-PRISE will be coming up with all the local law enforcement and the emergency care people. All right, thanks everyone.
Thanks.
Thank you, Steve.
Yeah, thanks for coming.